Hello, everyone. Welcome to my next bAIgel. Today I have a distinguished guest. It's Reijer Passchier, Professor of Digitalization and Democratic Constitutional State and Director of Joint Legal Technologies Program from Leiden University. Hello, Reijer. Nice to have you here.
Thank you for inviting me.
Let's discuss your recent book. You handle with AI in constitutional law. It's really interesting, and your recent book is on consequences of AI for constitutional powers. Can you tell us a few words about it?
Sure. So when we think about the challenges AI is posing for legal orders, we tend to think about material values and about specific human rights like privacy or the freedom of speech. A lot of attention is paid to the ways in which digitalization and AI is threatening these values and human rights. This is, of course, a very good thing that we pay a lot of attention to these threats. But on the other hand, all the attention we have for specific values is undermining our attention for the consequences AI may have for constitutional structures. More specifically, the constitutional structures on which the constitutional democratic state depends. More in particular, the separation of powers, the principle of legality, and the sovereignty of the state.
So how big this impact is? You told me when we discussed that one of the powers is more impacted by AI or stronger by AI or thanks to AI.
So take, for example, the principle of the separation of powers. According to this principle, the state is composed of three branches: the executive, the judiciary, and the legislative branch. In the ideal situation, these branches share the same powers. They are even. They are in balance. Well, now while states are digitalizing, the executive branch is digitalizing much faster than the other branches. Executives are using digital technologies for executing legislation, controlling citizens, etc., while legislatures, in particular parliaments, do not manage to benefit from digital technologies at all. And also the judiciaries lag behind. So digitalization is causing a disbalance among the three branches of government, which involves a lot of risks also for fundamental rights, and is making the controls on the executive even less stronger than they already were in a lot of places.
Mm-hmm. And do you find any solutions in your works, in your papers?
Well, one of the solutions is that the other branches, so the non-executive branches, should be much more stricter on the executive using technology. They should demand transparency, explainability, and controllability. Also, they should consider, I suggest in the book, to use technology themselves, to strengthen themselves by using technology. There's a lot of possibilities for the judiciary, for example, to use technology to be more effective in solving disputes and check the executive branch. And judiciaries should use technology more often, of course, while taking in mind that they themselves should also commit to constitutional and democratic values and use technology responsible. The same goes for legislatures and in particular parliaments. They also could use technology much more effectively to be a counterweight to the digitalizing executive branch. And they should also better inform themselves on technology and the consequences technology might have for democratic and constitutional values. So, for example, I suggest that parliaments should have much wider possibilities for technology assessment. They should have budgets for hiring experts and people who could help them to write qualitative legislation and to check the digitalizing executive branch much more effectively.
In Poland, we have same problem. Only a few judges follow the digitalization and use the new technologies. Is there any project in Netherlands implemented already to teach them how to use your solutions, how to implement them in real life?
Well, there are a few, including my own program.
Okay.
The program I direct, the Legal Technologies program. And there's some other programs. And in the past few years, there has been more attention also within the judiciary for digitalization and the consequences it might have and the risks, the democratic risks it might involve. So I'm I'm quite optimistic in this respect. On the other hand, the tech savviness of the judiciary still much relies on the interests of individual judges. So I hopefully, and I'm quite optimistic about this, but hopefully the judiciary as a whole and also as an organization will develop strategies to become ready for the age of digital technologies.
Okay, thank you for your sharing your experience. Thank you for a really interesting discussion, and thank you for being here.
Thank you so much for having me.
And you guys, see you next week, same time. See you. Bye bye.